524 on 710 KURV. Dr. Nathaniel Cogley teaches political science in Stephenville. That's where Tarleton A&M is, and part of political science is the occasional attempt to impeach and remove a president. Thanks for being with us. What would you tell if somebody says what went on today in the impeachment trial? What would you tell them?
Well, the House managers are making their case for Article 1, the abuse of power charge. And I think one thing that's very interesting here, the House managers are themselves representatives. They're active politicians, and they're playing to the home district. And as you know, we're a million miles from convicting and removing, and much of these accusations against the president has been about a narrative that the request for an investigation into Biden wasn't actually a national security concern or a corruption concern, but it was designed to help him win re-election, right? And so what's interesting here is what they're presenting now over these few days is they're already structuring the narrative for when they lose this trial. Okay, so we saw Nadler yesterday say, if you senators don't call the witnesses we want, you're complicit in Trump's cover-up. So that's a line they'll use after they lose.
That doesn't work. Can you imagine, though, sorry for interrupting you, but if you're actually at a court of law, criminal court of law, and you're a juror, and the prosecutor's like, you guys suck as a juror, it's
exactly.
like, that's not for your benefit, dude.
Well, that's my point, is that is not designed to win over some Republicans. That is designed for his home district, right? And then Adam Schiff today said, you know, the House managers are going to present their case. Then you'll hear from the president's counsels. Then you'll be able to ask questions. And this is a quote. He said, and then the trial will begin. I mean, this defies what's been going on the last few days. We're like day 3 or 4 of this trial. He says the trial's not going to start until they get to the witnesses. In other words, if they shut this thing down and not get to witnesses, he's going to claim there was never a trial.
Oh, gosh.
You know?
But then I thought Schumer today said that there was no talks of getting witnesses. So that's already out of, like, that's not going to happen.
Well, there's a timeline process for that based on the Clinton format. So we got to get through House managers making their case, the president's team making their case. We'll have 2 very fun days of senators asking written questions, and then we'll get to that point of to dismiss, and if not dismiss, will there be witnesses and maybe who? You
know, something we learned, and I keep on bringing it up because it blows my mind how nobody's really talking about it, is that the obstruction of Congress, that the House Democrats in Congress, if they wanted those witnesses, they could have gone to a court to make sure that they got those witnesses to testify because, and correct me if I'm wrong, that executive privilege doesn't fall under, you know, withholding these witnesses to testify. But what it does is it exempts certain things being said. So to me, it's like they could have taken that next step, but they chose not to. And then they're crying, oh, you know, obstruction of Congress, when they could have done that next step to do what they could to get those witnesses to testify during the House trial.
Well, exactly. That's what makes it a very weak charge. Obstruction of Congress is that they didn't take the time to make it an obstruction of justice charge, to actually go to the court system. You know, it's the court system that has set up the precedent of executive privilege over time. It doesn't actually appear in the Constitution. But what the courts have also set up is the House's subpoena power. The Constitution doesn't say anything about the House of Representatives having subpoena power. That's also court precedent. So the court has been creating that line, and the court needs to weigh in on whether or not certain people can be called forth or subpoenaed to testify. And you're right, executive privilege would be over certain conversations they may have had with the president, not whether or not they can answer any questions at all. And they didn't take the time. And their narrative about why they couldn't take the time was that Trump is a threat to national security. He has to be convicted and removed immediately and barred from office. And, you know, that's never been on the table. You know, in fact, if they wanted to make a stronger case, they would have taken the time. But what was really in a rush is as I've been saying, they need to do this before the Democratic primaries hit. You know, Pelosi's district votes on March 3rd. You know, she's got to go forward before March 3rd. You know, and so she didn't have time to go to the courts. At least that's my humble theory on that.
What would, if they'd gone to the court, it wasn't going to be answered whether or not they could subpoena and get certain administration figures to come testify under oath. This was going to take a while to get an answer. If it played out, even an expedited hearing would take a while. I assume that you're saying their reason was, well, he's such a danger, we need to act now. We don't have time to wait for all this. Is that what you're?
Yeah, but the courts can fast track this thing. I think there was a fast track movement on McGahn and then they withdrew that. So you're right. The courts can be slow, and the courts can, in exceptional cases, be fast. So we just don't know. They didn't pursue it.
They must have assumed they weren't going to get the go-ahead from the courts.
But even if the court said no, at least they could say, hey, well, we really did try, and now we can file the obstruction of Congress. But they didn't even do that step. So to me, it just sounds shady.
And obstruction of Congress we've seen before. It was one of the 4 charges against President Clinton, and it failed in the House. It didn't even go to the trial in the Senate.
There's a Pew poll today saying the country is about 50-50 split on whether or not to, slightly more, like 51% say get rid of Trump at the end of all this. How does this hit the public? Because they're not watching this. They're depending on news accounts, I would assume. Yeah,
I mean, you can imagine a vast majority of Democrats support this. Majority of Republicans don't. But those independents, I mean, I guess it depends what you're reading. You know, I'm looking at one right now that says only 48% support removing Trump. And there's some people that are the polls on did he do something wrong versus what should be done about it. Some people say there's something wrong, but we should have an election, not an impeachment trial.
Yeah, but they don't know
the country's very evenly divided. And I'll just say that actually is very important for why those Republicans from swing states want to be patient on this.
Yeah.
They don't want to just automatically dismiss. They want to be able to say to their swing state voters, I was patient, I was objective, I heard it out based on the totality of information.
But when people say that, oh, Trump must have done something wrong, there is nothing like, what has he done that's so wrong? You have Nadler today saying that Trump's conduct shows he's a continuing threat. And I thought, well, to who? I mean, who is he a threat to? And then you also had Nadler today say it's wrong to say a president can't be impeached because he didn't commit a crime. And to me, that just shows me or tells me, well, y'all have nothing on him. He didn't commit a crime. So what is this all about?
Yeah, there's a real nuance here legally that is kind of forgotten here. So to impeach is to call someone's character into question, but it's not to say what should be done about it. So while the Constitution doesn't really specify a crime to be impeached, in other words, your character in question, it does suggest that removing and barring from office would be treason, bribery, or other high crimes or misdemeanors, and they have failed to establish that. Now, in their articles of impeachment, they are saying remove from office and bar from future office. So they are all in on the extreme penalty, which would require treason, bribery, or other high crimes or misdemeanors, which they lack. So I would say lacking those, it's inappropriate to be here. This should be a civil case in U.S. District Court in Washington, D.C. at the most.
Because you brought up the whole Impoundment Act, right? So if this goes back to the withholding of the funds that were then later released, who was the one that should have sent the memo out? It was not the comptroller, but who was it?
The Comptroller General.
Oh,
the Comptroller General. Yeah.
And that they also failed to do that too. So could Republicans use that? How come we're not hearing this? That's what's getting so frustrating. That, like all the arguments that, hey, well, y'all could have done this. The Comptroller General could have sent y'all. That was their job. Congress could have taken that next step.
They have to answer the charges. I mean, at some level, I guess. Or maybe they're just hoping it'll go away and they won't have to.
Well, that's when it comes to the question of witnesses. There's some speculation about will we get these big witnesses, the Boltons and the Hunter Bidens and stuff like that. And I don't think that's going to happen. But I think we might get a witness. The GOA finding that I wrote on, I wrote a counter to, that's not part of the House report. Someone to counter that testimony wasn't in the House committees because this thing came out the day the trial started. So I could see some moderate Republicans from swing states saying, okay, before I vote not guilty, let's bring in someone from the OMB. There's only one person from the OMB, Mark Sandy, who testified. There's other people who could testify to explain why they followed their Impoundment Control Act and why their delay was legal. So you could get a witness that's just focused on the allegation of, even if what they're alleging is a crime at all, come in, a bureaucrat to give a technical answer. Then the moderate Republicans will say, well, we did call witnesses and we did hear from people the House didn't, and at the end of the day it was not guilty.
We got to bounce, but thank you very much for your analysis and your thinking, and we will call on your brain another time. Thank you very much, Dr.
Nathaniel Cogley,
Dr. Professor, whatever.
One of our favorite guests, Dr. Cogley, who teaches political science at Tarleton State University, our guest on 710 KURV.